Okay, so here we are, friends, with our another episode of our talk show, The Global Resolve, where it's all about mediation, and we get influencers and thought leaders from across the globe who share the views and perspectives with us on mediation. And today we welcome Mr. Anubhav Kapoor, who's the General Counsel for Ford Motors India. Welcome, Mr. Kapoor. We'll have your views, your suggestions, and your perspective on mediation. So let me straight away get on to the questions. I'll start with the first one with the permission. What do you think is mediation as per your point of view? And do you think it is just a negotiation or something more than that?
First of all, thank you, Sanjeev, for providing the opportunity and WLA. I think it's a very interesting topic and something which is close to my heart as well. And more recently, I think, given the load on the Indian court systems, this discussion has become very current and relevant. So, so it is at a very apt time that we are doing this discussion, and probably I'll try to share my experiences and views as part of the corporate world, right? So, so to your first question, I think, Sanjeev, what is mediation? So if you get into the technical side of it, I think it's a voluntary process, right? Where kind of parties try to resolve their conflict using a third party, which we usually term as a mediator.
Right.
And during the process, I think the parties who commission the mediation try to kind of resolve a conflict, right? And the mediator helps them to reach a common point where they can agree or resolve the conflict. But this is an attempt, not necessarily that every mediation kind of lands up in a settlement or a resolution, right? So that's the beauty of mediation, and mediation has been very commonly used from time immemorial, right? There are references of it even in the Greek mythology of mediation, though it used to be more conducted by the village elders at that point of time, or the panchayats, but it was that was a form of mediation and was very commonly used for family matters or civil matters or community related conflicts, or and now it is much more used for civil and commercial matters, right? So it I think has a lot of potential as a form of alternate dispute resolution mechanism. And of course, it has its own advantages and also its share of why it is not very popular as well, right? So we'll discuss a bit more as we go through it. But as of now, I think that's what I think. It's a powerful tool which is available for us to resolve conflicts.
Great, Ji. Thank you. So that was actually coming from heart. And when a general counsel of a corporate would say that it's close to your heart, it really means a lot. Now let me ask you a connected question. ADR, when we speak about, you also mentioned about alternative dispute resolution. Now half of the world, or more than that, when we interact with them, ADR, the discussion starts on ADR, it ends up with only arbitration. So what happens is, though mediation is taken as one of the tools of ADR, but somewhere people don't even carry on with that distance, and they stop at arbitration. For them, that's what ADR is all about. And frankly, if you go deeper, mediation, though being a tool or a mechanism of ADR, is actually poles apart. It's collaborative, it's voluntary, it's confidential, and totally flexible, creative, out of the box thinking. So how do you see that? Is that an awareness issue, sensitization, or something else which is preventing the acceptance?
I think there are you have touched the heart of the problem in terms of one. I think it is wrong to say, or I think it has been wrongly classified that ADR is a domain of the lawyers only, right? I think because of that impression, because lawyers in our current system, which is actually an adversarial system, right, where two parties are either have to win or lose. They are competing with each other on a solution, right? That's the system we are used to in a litigation world, right, or in a litigation environment. But when you talk about mediation or say conciliation, this is not about adversarial behavior. This is all about collaborative behavior. It is all based on a discussion, right, where parties try to come together and discuss in an open environment and with an open mind, and try to find say next best alternatives to a particular conflict situation they may be in, right? And this is supposed to be more informal, more where the parties can participate more freely rather than a very procedural driven legal system, right? And it could involve also more involvement of the parties who are actually facing the issues or who are in a conflict, rather than someone else representing you all the time and you only speaking through them, right? So I think it has many advantages, right? And I remember long back, Sanjeev, when in US there was an employment dispute that I was in, and the employee was terminated, and he made a claim of a few $1,000s, like almost not very large, but say 100,000 as an example, right? And we went for a mediation before we went to the court. Okay. Now this lawyer, obviously, see, these are seasoned people, right? And I remember going into that whole meeting, he invited the officials of the company with authorizations, and of course the terminated employee. So he put us all together in two different rooms, right? So in one room, he was trying to kind of tell us why this guy should not have been terminated properly, the way you terminated them, and why he is eligible for what he's asking, and trying to set up for expectation, because we were almost at a zero level, right? That we are not going to pay him, and because of several issues. And on the other hand, later we knew he was trying to do the same expectation setting with the employee, saying that, yes, you did not do this, and therefore, but you are not eligible for this point of settlement as well, right? And I think he played kind of in between both the for 2 or 2.5 hours at a point where he felt that there is a common ground, and that's the point. He invited us into a room, and very tactfully he said, then he explained the legal position of the matter, because he is obviously a judge, right, of a county court, and then he very objectively explained the business rationale of why the company should be paying, and the business rationale why the employee should not be asking, and then giving a solution. So I think at the end of the day, we shook hands. We settled at an amount which we both were happy, and walked off. Now, I think investing that 2.5 hours was much more useful for both the company and the litigant, rather than getting into a long drawn expensive litigation where probably I would have spent more money than the claim itself. And went back, right? So I think there are several advantages if it is done tactfully and comprehensively, right? And so therefore, to your first comment why it is close to my heart, because in a corporate environment, I feel negotiation is still the best way we resolve conflicts, right? When there is a situation, I think we do have even very active clauses in the contracts where on dispute resolution, where the first step is a negotiation or a or a soft mediation, so to say, between the officials of the company, right? And where the company, both the sides discuss openly what the issue is and try to kind of come to a commercial settlement or give and take where it can be moved forward. It not only preserves the relationship, but also kind of the way media now pulls the corporations. It also protects a lot of our confidentiality, brand image, and things like that, right? So, and especially I've worked a long years in software. I think in software, the reputation is a big thing, and it's a lot on stake if you don't perform well, because it is a services industry, right? And therefore negotiations and mediations, I think, are the maximum used tools to resolve conflicts. So as a corporate lawyer, I think I have used them more than once, and on several occasions we have received very good results. In fact, most of the time, right, we have received, and there was only a very few times where we had to go to a court, especially on the commercial negotiations, because I believe everything can be settled. If sure, Sanjeev, I think the question is extremely interesting, and it can go in many directions, right? Yeah. But today, I want to take it to a different direction, which I usually hear in many of the forums, right? And I'll tell you what I mean by that. In many of the forums, I've seen a lot of discussion happening on the mediation as a process itself, right? And the whole mindset of how the process should be conducted, what should be the qualification of the mediator, how the resolution and the tactics should be applied, and at what stages it should be applied, and things like that, right? But at the end of it, I think all these processes are about finding a resolution to a conflict situation, right? That is the end result of it. Okay. And I seldom find any discussions on what is going on with the people who are in the conflict, right? How is their psyche running, or what state of mind are they in different part or different stages of the conflict, right? So if you turn the table and start looking at how these litigators or the people who are in a conflict situation dealing with the conflict, rather than focusing more on the mediation procedure, whether there is a legit way of doing it or not, whether it will have the enforceability of law, I think those are all important considerations if you are not able to find a solution in the normal course of things, right? And I think since time immemorial, the basic things in which the human race has been finding solutions of conflicting situation is discussion, negotiation, and also in terms of a certain type of obedience or reasonableness, as I would call, right? Because people have to, in a conflict situation, be a little more reasonable. They cannot be only on the thing that what I want. They have to also, over a period of time, think what is the other party wants, and that is where the whole win-win situation happens, right? And let me share something which I want to share in terms of the different perspectives and on which the pillars of a resolution are based on, right? And what does it take to get a resolution or get into a zone of settlement, right? And this is purely from, and there is no law in this, there's no legality in this. This is purely from how I see it from a person who is in a conflict situation, right? Just give me a minute. Let me share what I think, and please feel free to pitch in wherever you think you need a little more explanation. So Sanjeev, are you able to see this?
Yeah, very much, absolutely.
Yeah.
Yeah.
So what I feel is that that when a litigation begins, right, and I'm here, this is the start and this is the end axis, and I have plotted different factors over different parameters, right? And the first parameter is, say, emotions, right? And this is a red thing. So the way you should read this chart is that this red should correspond to the red line that you see on the map, right? So at the start of a litigation or a conflict, the emotions of parties are extremely high, right? They are to the extent that they are either denying the fact that they are in a litigation situation or a conflict situation. I've seen people who are simply denying that they are in, right? They simply want to avoid it. That's the kind of reaction, or which later kind of turns into an adversarial or a competing mode. But also at the stage when the emotions are extremely high, people aren't listening too much. They are hearing, right? They are only hearing what they want to hear, and they aren't listening in terms of how to solve a problem, right? They're only telling what they think is the right, how reasonable they have been, their side of the story, right? They aren't listening enough, which would really create a solution, right, in that, for that matter, and create a balanced view. And of course, at that point of time, the trust between the parties is extremely low, right? And those are, I think, the pillars on which a settlement or a dispute begins, right? So when you talk about emotions, right at the start, I think the emotions are extremely high. People are not able to think from their head, but they use most of their heart to discuss it. And this is interesting. And because what we want, and then but at the end, when they are in a mood of settlement, over a period of time, over the dispute, I think because of the frustration, or they realize the reality of the situation, they by then also are more aware of what situation they are in. Their emotions become lesser and lesser over a period of time. And when at a point of a zone of settlement, their emotions are actually more reasonable, where they are able to think not only what they want, but also think in terms of what will lead to a settlement, in terms of a win-win, what others want, right? And similarly, see, if we get to the conflict resolution stages, early stages of the litigation, and I'm on this reasonable changes in mindset, I think over a period of litigation, the mindset of the people who are in a litigation situation also change, right? And there are other factors as well, right? But you can't assume he is the same state of mind, say at point X in a litigation, and say point Y in a litigation. I think over a period of time, because of many factors, his mindset is also changing, right? And typically what we find is, given that we are conditioned to an adversarial kind of a mindset, where either you solve problems through either a fight, right? Either you win or lose, right? There is nothing in between, right? Or in terms of even a typical litigation environment, you go to a court of law, and when what you call justice is probably the procedure happens is you present your case, the other party presents its case, and there is a judge or the adjudicator who determines who is right or wrong, right? So in a typical adjudication, in a litigation, there is a winner and a loser as well, right? And therefore there are all the rights of appeal, and it becomes a very long process, right? But as I told you, in a mediation, I don't think the mediators should spend a lot of energy, or they don't even usually, to find out who is right or wrong, right? I think the whole energy is spent on discussing in an open environment, getting to a solution, and finding a settlement which the parties can agree to. So in the beginning of any litigation, I think typically, because we are conditioned to that mindset, we are usually in an adversarial or a avoidance mode. And then suddenly, once we realize that, yes, we are in a litigating situation, so instead of solving it, we get into a competing mode where we want to prove our point as against the other's point, right? And that's what I think I would attribute 60 to 70% of that because of the environment we have always been there, right? It is the conditioning of our mind, right? We are not conditioned to solve a issue by, say, discussing on Batna or what is my next best alternative, right? To a dispute, which is a very common technique that we would have heard, right? Or for matter resorting to discussions where we can consider or give away what the other party wants. And probably this could be also attributed to egos, different cultural kind of traits that we are in, right? And there is no single answer or yes or no on this. I think this is more towards the overall environment in which that dispute is running or being conducted, and the parties and their background in which the dispute arose, right? But the normal reaction we see, at least in the Indian environment, is that people start competing in it because that's how they are conditioned, right? Then over a period of time, because the courts take a very long time to resolve, there is a little amount of frustration, and also there is a realization as he goes through the dispute where he could also be wrong, right? It is also a fact that at some point he starts realizing that yes, if he did 3 things right, he also did two things wrong on the other side, because of which the dispute has come, right? So over a period of time, he starts becoming more accommodating, right? And that's the time probably a skilled mediator should also watch for, correct? And all these 5 or 6 points, I think the mediator has to be skilled enough, trained enough, and smart enough to gauge the points of resolution, because that's the turning point, right? His mindset has now started towards a more at least accepting that he may also have done wrong to the other party. He's still not in a mood to give away whatever he's asking for or give it to the other, right? But over a period of time, I think he gets into a collaboration mode, because that's where the counsel is coming from, the opposite party and the mediator, and he gets more knowledgeable about the facts, his legal positions, and what will happen, and if he goes to the court, ultimately what is the relief the court is going to give that person. And then I think somewhere he then kind of gets to a mode where he weighs down his own pros and cons, takes the counsel from the mediator or his lawyer, and gets to a zone of settlement, or where he's willing to get into a compromise. And that's the win-win point, right? Because he's willing to not only take what he wants, maybe a shade lesser, but also willing to give what the other party wants, because without the give and take, there cannot be a win-win, right? So what I also feel is that a mediation process, unlike litigation, right? The litigation doesn't consider all these 5 factors. The advantage of a mediation or a conciliation is that because it is more personal, you have much more degree of control over the process. The mediator has personal touch with the with the parties involved. He can go through this change in the mindsets over a period of time of the parties who are, and a good mediator definitely will know where the turning point or the inflection points are, right? Because that's the way the discussions change. Sure. So trust, I think, wavers over the period of time, and it is something that the mediator has to kind of moderate. And I'll just what are the common trust issues that a typical mediation would have, right? I think the mindset of the litigant, the people are please don't trust the other party, right? Because this guy has been unreasonable to me. He will also be unreasonable in a mediator. I won't be able to get justice. Otherwise, मैं तो बोल नहीं सकता हूँ, वो तो बहुत अच्छा बोलता है, I will get robbed. So don't trust this process, right? Because it has no court of, this is not legit. It doesn't have the force of law. Let the court give the justice to me. Whether even if he loses there, he will mark it to this destiny, rather than saying, but that's his fait accompli, right? That is where the finality of the decision comes. But in a mediation, usually this is the fear that the parties involved will have. Then probably there is also one more indicator that we often see. They say the mediator doesn't understand the full, वो तो lawyer है, उसको क्या समझ आएगा, right? Or and therefore, I think this has become more constricted to lawyers, while I think mediation can be done by anyone who has the experience and the maturity to resolve a conflict, right? But this is again the common mindset, because people believe in the legal rules, and that is how the society or the system has been formulated. The trust on the mediator also starts with a very low point, right? And in Indian society, where I think corruption is part and parcel of the overall scheme of things, right? There is a very common belief कि दूसरी party ने खरीद लिया होगा और उसको there's a bias, and so there the trust factor again is lacking, right? But the fourth point is more important, I think. What I have also seen is 50 to 60% of the people who are in the mediation, they don't know what they want, right? They are into a conflict, yes, but they don't have the clarity of thought in terms of what the end resolution should be, right? Or what is exactly that they want. Their self-confidence or they are in a state of self-doubt, maybe due to high stress levels or decision making, or it could be, but this is the important factor, because once the person is clear in terms of what he wants, then the solution is easy to find. And of course, there are third parties and influencers who kind of derail the process as well. So when I thought, how does the trust factor move over a period of time in a litigation, I thought the trust factor has to be reinforced, because it is in an ebb and low, and a skilled mediator has to reinforce that his case will be solved. He's in good hands. This is the solution that you want. He needs that counseling to build that trust and keep it at a high level. So having said that, which I think are these are the three main pillars of any settlement, I think mediation, right now we attempt it at an early stage mediation. So at an early stage mediation, the rate of success is bound to be low, because you are in a high emotional state. You are only thinking of what you want. You are not considering the other party's requirement, or not even realizing that you may have done a few wrong things. Your trust is at a very low level. I think any early stage mediation more acts as an awareness program rather than a dispute resolution program, in my opinion, right? So while I think the textbook says that early stage mediations are the ones which are recommended, because the parties may find an early resolution, they may save money, but this is also one of the bigger factors where a lot of settlements do not happen at early stage mediation because of these factors. But I think what I think is that there is an opportunity of a resolution at each and every stage of a dispute or a conflict, right? And there has to be attempts of mediation on a periodic and continuous basis, right? Based on how the people in a litigation, even if it is a litigation, I think the judges should be more conscious that they should give opportunities to the party to go back and do an interim check or assessment whether they can find a resolution after speaking to between themselves, rather than someone adjudicating who is right or who is wrong, right? So I think a mediation is a very powerful tool. even in the interim process, and there is a high level of or high degree of possibility that a resolution can be found in the midterm, because that's where things are coming to an inflection point. But over a period of time, I think invariably, Sanjeev, what I've seen is that things settle, right? There are very few things. I think 60 to 70% of the matters, because of the longevity or the length, they tend to settle out, right? Because at that point of time, what I have termed it as a zone of settlement, the psyche of the litigator has changed quite a bit as compared to what it was in the start, right? The emotions are ebbed down, they are at a low, right? He's willing to listen to the counsel. He's more willing to kind of and partly that is because of frustration also, but more because he realizes at that point of time that he has he also owes the other party a few things, and also he's more in a compromising state of mind, and his trust probably not at the lowest. He is still at a state where he can take a rational decision for a settlement or a compromise, right? Now, given this framework, I think it answers a number of questions that why mediation is a powerful tool in any given conflict, because it affords the opportunity of a settlement or a resolution at each and every stage of a dispute, right? Unlike the typical litigation scenario, unless the judges are proactive and provide that opportunity at various intervals, right? And also this answers why early stage mediations are not very successful, and that is one of the reasons why people do not trust it or too much, because if 80% of your mediations are a failure, and it is not because of the mediators, it is just because the parties don't have their heart and mind to find a solution to that mediation process, right? So that also explains why people are not accepting it the way they should, because this is the right way of doing or solving any dispute, you see. I'll stop at that. I'm sure you'll have more questions for me.
Yeah. No, so that was one go to whatever is the next best. But a court annexed mediation, would it have the similar impact? So your take.
Yes, Sanjeev, I think a court-driven mediation is also a very effective tool, and we should mix a pure litigation proceedings with periodic opportunity for the parties to speak and find a resolution. And that is where in my previous slide, I think even in a litigation situation, the mediation should be there almost mandatorily at a periodic intervals, right? Because the litigants aren't in the same state of mind. Their awareness about their own case is increasing over a period of time, right? They are also becoming more knowledgeable what are their rights, where they can get wrong, or what they are getting more aware in terms of how long it will take and what is the urgency to settle. Because in any dispute, I think 2 or 3 factors play a major role. And even as compared to US, we are still cheaper. But even in India, justice does not come free. It has a cost to it. And the lawyers are only getting more expensive, right? So the resources, and the procedures as such, you have to go in every hearing to them, to the courts, make appearances, attend hearings. So I think the urgency, the resources, the financial constraints, and also the awareness. Now, the first thing now, if you're hit by litigation, a common man will go to Google and find out what's the law of the land, right? And he doesn't have to wait for an attorney to visit an attorney. He can find at least the first 20-30% of his knowledge right in the click of a button on his phone, or a so I think the dependency is also loosening up a bit. People are becoming more smarter in terms of their awareness from the social media and the public knowledge forums. And so therefore, I think court-led litigation can also be very effective if kind of we mix it and marry it through a litigation procedure. And I think it can reduce the burden of the courts as well substantively if people are becoming more proactive in solving their own problems.
Got it. So, okay, so the last bit now, do you use mediation any which way, in parts, in piecemeal in your organization? Do you wish it can increase further? And would you want to experiment further on how else mediation can reduce the conflict, dispute it, sensitize people? You give few ideas, I give few ideas, we get more ideas, and like, at the end, whatever is the hybrid solution, which probably can work wonders for everyone. So I think that with that note, we would want to, conclude this session. This was very enlightening. You really took us through and through with your experience, exposure, and of course, the, very valuable insight through the slides. So anything which you would want to say as a parting statement, with regards to the initiative and with regards to mediation again? So it's not an answer to any question. It's just from your mind.
Sure. No, Sanjeev, I think I'm delighted. We have champions like you who are propagating this in spite, because any of such breakthrough initiatives requires the energy and change agents, and I think this is something that we really need here in this country, given that the smaller disputes aren't being addressed the way they should be. The speed of justice is definitely, we need to improve on that. And there is so much we can contribute as professionals to this cause, right? So, So very happy to be part of it and have this deliberation. Though I think I did not touch upon the core legal issues and the industry, but what I wanted to really bring out was what is the psyche of a litigant or a person who is involved in a litigation, and why the skilled mediators are required, because it is a tough task to go through and conduct these proceedings. People take it lightly because they are not binding or they are voluntary, but I think there is a lot of substance if you do this seriously and take this seriously.
Got it. Great, sir. So thank you, Mr. Kapoor. This was, time well spent for a noble cause. And I'm sure, these steps, though we call them baby steps, but they are going to make a, much bigger impact and difference, in the way things are going to happen going forward. So let's hope for the best, and we'll definitely come back to you, with another session, and then we can, take forward our discussions today, what we had. So thank you once again. And we'll conclude on this note. Okay, great. Thank you, sir.
Thank you.